You're listening to Heavily Accented Philosophy of Law, a podcast powered by the HAPL Project.
In this episode, we have Francesca Poggi from the University of Milan. Francesca, welcome.
Thank you. Thank you for this invitation.
Today, we are going to talk about legal interpretation, the possibility of the conversational model applied to law. But before starting with the substantive questions, maybe we can ask the same question of the other episodes. So basically, what was your academic path to the present? Where did you study? What were your topics of research, etc., etc.?
Thank you. Well, I studied law at the University of Genoa, where I graduated with a dissertation on normative meaning under the supervision of Riccardo Guastini. When I did my PhD at the University of Milan, and my tutor were Riccardo Guastini and Amedeo Conte. My PhD thesis was about permissive norms, and it was also published a century ago, more or less, in 2004. In the meantime, I became a lawyer, and I worked as a lawyer in Genoa, mainly in the field of maritime labor. Then I won a few research grants and finally a permanent position at the University of Milan, where I stayed. Now I'm a full professor at the department Cesare Beccaria, and I'm the coordinator of the Cesare Beccaria PhD program in legal science. My main fields of research are general jurisprudence and in particular legal interpretation and the theory of legal concepts, law and bioethics, where I focus mainly on Italian bioethics legislation and case law, and more recently, legal gender studies, where I'm inquiring legal gender stereotypes and the concept of gender-based violence. This is more or less my research.
Thank you so much, Francesca. I'm going to switch a bit, move it to an academically personal note. I enjoy immensely your work. If we were talking 5 years ago, I would have probably asked different questions, all related to the things that I was doing at the moment when I was writing my PhD about hermeneutics, Emilio Betti, the tradition of hermeneutics and its relation to theories of legal interpretation and so on. And I was very happy to find your work and to use it a lot in my work. Oftentimes, when I was thinking about a topic, you came out with a paper which was basically very congenial with the things that I was writing. The things that come to my mind now is this idea of how important intention is in legal interpretation and what becomes of intention when a text, an utterance becomes materialized, when it becomes text in the sense proper. So today we are mostly going to discuss this theory of legal interpretation that you have been developing ever since your PhD. And the first question I would like to ask you is, what are the main elements of this account of legal interpretation that you developed?
Okay, thank you. Actually, I'm still working on developing a satisfactory account of legal interpretation. It is a work in progress, and I have not a finally ultimate theory on legal interpretation, not yet. I adhere to a legal realistic view on legal interpretation, which is basically built on the thesis of the so-called Genoese skeptical school, started by Giovanni Tarello and continued by Paolo Contucci and Riccardo Guastini. Probably the first and most important thesis is the distinction between legal provision as text and norm as meaning, and the idea that there is not a two-way correspondence between them, between a legal text and its meaning. Two legal provisions can express, at least partially, the same norm. The same legal provision can express two or more norms disjunctively. And there are implicit norms, that is, norms which are not the meaning of any legal provision or combination of legal provisions. The absence of a two-way correspondence between legal text and norm implies that there is never a single true meaning, a unique interpretation. It also implies, I think, that law is the product of a collective activity of legislators and judges. Legislators create text, judges fix their meaning by choosing from a range of possible interpretations. In many legal systems, judges can also change over the time their previous interpretations, and therefore they can change the content of law. This happens especially in civil law countries, but sometimes also in common law systems. To give you an example, consider the case Dobbs against Jackson Women's Health Organization. From 1973, the decision Roe against Wade, until 2022, the USA Constitution provided, under certain conditions, for an implied right to abortion. Since the Dobbs case, it has no longer provided for it, and the text of the USA Constitution has not changed in the meantime, at least not as far as the relevant provisions are concerned. Sure, this introduces elements of certainty. But by contrast, if an interpretative decision becomes consolidated, if most of the judges follow it, this reduces the indeterminacy of law and contributes to its certainty. I think that the absence of a two-way correspondence between legal texts and norms is due to many factors, and the indeterminacy of common language, of ordinary language, is only one of many. In my opinion, another important factor is the opacity, the indeterminacy of relevant legal context. It is generally assumed that every legal provision must be interpreted in the light of other relevant provisions, norms, and principles. However, how to identify which provisions, norms, and principles are in fact relevant is a matter of dispute. That is to say, the relevant legal context is itself a product of legal interpretation. In the legal field, the context is almost never common knowledge, but something that needs to be reconstructed and therefore gets contentious. Finally, another factor which contributes to the absence of two-way correspondence between the legal text and norm is that in most legal systems, there are many accepted interpretative criteria. Each one can produce a different interpretation and do not exist meta criteria to choose among them. So judges enjoy a margin of discretion and are also or could be influenced by their ideological preferences, moral preferences. At the end of the day, they are human beings. Of course, much also depends on the specific legal culture and system at stake. I would like to stress that my theses are not normative nor conceptual. They are descriptive theses. And in fact, nothing can rule out the possibility that in a given legal system, there is only one admissible interpretative criterion, or that a rigid hierarchy of interpretative criteria is legally established and constantly followed. However, as a matter of fact, many of our current legal systems are not like that. These, I think, are in short the core elements of my view on legal interpretation, but of course, there are still many problems to be addressed and many aspects to be refined.
As you know, I am sympathetic with your position on legal interpretation.
I know,
and
Julieta.
also with it. But I will press you on this, the last thing that you were mentioning in regards to what are the problems that need to still be addressed, or maybe some points to further develop.
Okay, thank you. Yes, the problem basically is that if my view were correct, we should expect a much greater number of judicial conflicts than the one which is actually present in our legal system. Sure, interpretive conflicts do exist, and they are many. But they are, in any case, less extensive than they should be, assuming that there is no objectively correct interpretation, or that which interpretation is correct is decided by the judges themselves. I think that this is due to social, factual, and psychological constraints on judicial arbitrariness. Many authors have explored these types of limits, of constraints, Scandinavian and American legal realists, for example. But I think that it's still missing a general framework. As I said, law is a collective enterprise, the product of a collective activity of legislators and judges, and I've also had of lawyers, scholars, and laymen. All these subjects interact, condition, and limit each other. It would be wonderful to have a model to explain such interactions and how they can also reduce or prevent conflicts. Such a model maybe could also solve another problem of my view. If my picture were correct, then it would not explain how it is possible that people very often follow the law and indeed behave in accordance with law before it is interpreted by any judge whatsoever. Here too, I think complex social conditioning is at work. Oliver Krohn has inquired this aspect, for example, as Julieta knows much better than I. But I think that there is still work to be done. Obviously, all this stuff is for years to come. These are topics I have not yet studied in depth, and I hope that I will have the opportunity to study them in future.
Yeah, definitely you are among friends when it comes to realist positions in legal reasoning and legal interpretation.
Oh, yes.
Absolutely. But at one point when I was working, and I think it might be the time when I was working on my PhD, we had guests from the United States. And let me start with this story. And you all know the guest, and I won't mention names because of the story. One of the guests was doing a thorough presentation on legal interpretation, and I asked in which he was claiming that legal interpretation is conversation. In which, and I was rather young, and I imprudently asked the question, when you're reading Dostoevsky, do you say that you're having a conversation with Dostoevsky? And needless to say, this has put some distance between us for 10 years after that question. But later on, I was thinking about this problem and just disregarded it as something implausible. But one person wrote a slew of papers criticizing this view from an analytical standpoint. And at the time when the papers were published, I enjoyed very much reading them. Francesca, those papers were yours, and I would like to hear something more about it. What are your main criticisms of conversation as a basis for analyzing and understanding interpretation?
Okay, thank you very much. If you agree, I will start with a broad picture of a conversational model. Okay, basically, I think that the conversational approach to legal interpretation is a kind of intentionalist approach. Broadly speaking, according to an intentionalist approach, the meaning of a sentence is the meaning that the speaker intends to convey by uttering it. According to conversational approach, in order to grasp this intended meaning, we have to rely on the rules that we usually follow in our ordinary conversations, and in particular on pragmatic rules, such as Paul Rice's conversational maxims. Certainly, there are many differences between the various conversational approaches. Possibly the most important difference is between the prescriptive and descriptive conversational approaches. Prescriptive theories claim that legal texts should be interpreted according to a conversational model, even if they are not in fact. So, for example, this position is advocated by Macagno, Walton, Sartor, Capone, and to a certain extent also by Ramirez Ludena. Or alternatively, prescriptive approach argue that legislators themselves should follow the conversational model in order to make their communicative intentions transparent. For example, I know that Flavia Carbonell and Costanza Innen are working just now on this thesis. By contrast, descriptive theories claim that conversational model is already applied in legal interpretation, and in particular that legal interpretive criteria, or some of them, are identical or similar to Brycean conversational maxims. This latter thesis is held, for example, by Sinclair, Milles, Locum, Carston, and to a certain extent also by Marmor, Morra, Scotchen, Bianchi, and Polworthy. I would like to stress that the first author to argue in favor of a conversational model of applicability of a conversational model to legal interpretation was Sinclair in 1985, so a long time ago. But since then, many authors have argued in favor of this model, often without quoting before Sinclair. So I would like to quote him here because he has his merit. But as you said, I think that the conversational model does not work in the legal field. As a matter of fact, the Brycean cooperative principle, the pragmatic rules which guide our ordinary conversation are not followed in legal interpretation. In particular, I think that in legal interpretation, it lacks a general expectation that certain criteria will be spontaneously followed in a certain default order. That is to say, legal interpretation is not a cooperative enterprise. Ordinary conversation in Brycean and post-Brycean, I will not distinguish the stuff here, but in Brycean, post-Brycean, and neo-Brycean framework is cooperative because speakers and listeners rely on the very same criteria in order to transmit and grasp speakers' intention. And they rely on the very same criteria simply because there is a general mutual expectation that they will. Instead, in legal interpretation, such general mutual expectation is absent. But why is it absent? Or, I know this is a different question, but the answer is partially the same. Should legal texts be interpreted according to the conversational model, even if they are not in fact? I think that they shouldn't. In my opinion, there are two core elements of a conversational model of ordinary language that are problematic with respect to legal interpretation. And these two core elements are the legislative, the speaker intention, and the relevant context. Firstly, it's very questionable to speak of a single legislative intention. Understood as a communicative intention, so understood in the Brycean way. Summative accounts of legal interpretation do not work. By summative account, I refer to such account according to which the legislative intention is just the sum of a single intention of the members of the parliament. So, it is well known in literature that this account produces some paradoxes and generally speaking does not work. But also, the most plausible theories of collective intentionality do not work at this respect. The point is a little bit technical, but briefly speaking, the most popular and plausible theories of collective intentionality usually require that collective intentionality emerges from individual intentions with some at least partially coincident propositional content. But here the point at stake is precisely whether the members of parliament the individual intentions of the members of parliament are directed to the same meaning. So I think that such kind of theory do not work. Also, some authors shift from the idea of a real legislative intention to the idea that we can simply conceive of legislative intention as an objective counterfactual intention. So it doesn't matter if actually does not exist a really unique legislative intention, which can reconstruct such a legislative intention. We can conceive it of as the intention that a rational cooperative legislator would have expressed it by enacting the provision at stake, or, which seems to be the same, as the communicative intention that a cooperative rational interpreter would ascribe to that provision in that context. For example, Wolfi follows this path. But I think that the very idea of an objective intention is questionable, because such objective intention can be reconstructed in many different ways due to the opacity of indeterminacy of legal context. Different interpreters of the same legal provision can reconstruct the relevant legal context in different ways, and therefore they can reach different interpretations. If we conceive of legislative intention as an objective or counterfactual intention, it becomes almost an empty notion. Due to the indeterminacy of legal context, and especially of legal context, there are many different ways to reconstruct the legislative objective intention. And that is important, we lack a criterion to decide which one is better than the others. But you could ask me, is it not the same in ordinary conversation? Because also in ordinary conversation, the context is huge and is sometimes doubtful which contextual elements the speaker has assumed as relevant, and therefore which contextual elements are relevant in order to infer the speaker's communicative intention. However, I think that it is precisely Gricean cooperative principle which guides the recognition of a relevant context. In ordinary conversation, the relevant context is the context which is or can be supposed to be mutually known and which makes the speaker's utterance cooperative. In ordinary conversation, we have a criterion that permits us to know when the construction of a relevant context and therefore the communication has failed. If a speaker's actual communicative intention does not amount to what I think she intended, then the communication has failed. But nothing usually happens in statutory interpretation. I think that briefly, the most important distinction between ordinary conversation and legal interpretation relies on what Mario Iori has called their metapragmatics. By metapragmatics, Mario Iori means the typical function of a language as a whole. I think that understanding what the speaker intended to communicate is the success criterion for ordinary communication, because ordinary communication is a means to understand each other. The main function of ordinary conversation is to allow people to understand each other. In ordinary conversation, we are cooperative because we share this basic purpose of understanding each other, maybe even in order to argue. When I speak of a linguistic operation, I only limit myself to a cooperation which is directed to understand each other. No a cooperation in the sense that we are all a friend and we want to give things together or something like this. We need to linguistically cooperate also in order to argue. It's not possible to argue if you don't understand each other. And after all, even if in ordinary conversation, even if we cannot fully understand each other, usually it makes a little difference. It is usually enough that we understand each other sufficiently, more or less. So the meta-pragmatic of ordinary language is determined, is fixed by the essential function to make people understand each other. And this is the main reason why ordinary language works spontaneously. But the meta-pragmatics of legal language, of legal interpretation, is very different. It is fixed by its conflictual nature. Legal language doesn't work spontaneously, but it must be administrated. And legal language does not work spontaneously since law affects many personal interests. On legal interpretation, many important things depend. It affects a lot of personal interests. In interpreting law, legal actors push many different goals. So we are not cooperative, and it is not enough to understand the legal meaning more or less. So this, I think, the most important distinction between legal interpretation and ordinary conversation, and the reasons why the conversational model is not applied and could not be applied to legal interpretation.
It is a very interesting, let's say, set of issues that you can have when you think about law and the practice of law as being some kind of a conversation among different participants, also because not all the participants within the practice have the same roles or have the same goals. But I have a follow-up, which is a very brief one, in regards to this idea of law and legal contexts not being cooperative. I agree with you. I see the same, specifically when you consider some parts of the legal practice. But then I was thinking maybe in which sense we can say that the relationship between different legal authorities is not cooperative. Because I can understand, for example, naturally when we are thinking about trials or judicial processes, naturally this is absolutely non-cooperative in this sense. But then I was thinking, for example, in legislative interpretation, that is in some sense more of a relation between legal authorities. In which sense this can be considered to be non-cooperative?
Okay, by non-cooperative, I mean that it doesn't follow the Greissian cooperative principle. Greissian cooperative principle is a general principle, but as I said, is directed to make people understand each other by presumed that they follow certain specific Greissian maxims. It's obviously that I think that public authorities interact. They influence each other, they have a great number of relations, but this their interaction cannot be modeled according to that specific principle. I think that the problem is many people do not see how technical is Christian theory. It's not simply a matter of have engaged in some kind of cooperation. Okay, it assumes that we follow some specific maxims. For example, the maximum relevance or the maximum mood, any specific, and not everything which is implied is a Graecian implicatum in a strict sense. There are very rigid rules. So I do not neglect that public authorities interact and influence each other. But this kind of influence is very different from the influence, from the linguistic cooperation that we have in our ordinary conversation. For example, the quantum of implicated, I cannot use implied because implied is for logic.
Yes, exactly.
While implicated is for conversational implication. The quantum of implicated content in a sentence is enormously less than in an ordinary conversation. But why? Because judges do not trust of their listeners. So they do not trust, it means that they do not assume that their interpreters will be cooperative. So you have to do a much more great number of explicit content. I hope it's clear enough.
Absolutely. It's fantastically clear. And I very much enjoyed your elaboration of these problems. And then I'm switching to a very difficult question. Like, it might be the question that overarches all issues in legal interpretation ever since the inception of legal hermeneutics at the end of the Middle Ages, basically. And it's the question of objectivity. I am, by my very nature, might be very dubious of the idea of objectivity, but there is much nuance from the perspective of the things that you have been telling us about and the perspective of your position. It seems, at least always seemed obvious to me that that this idea of objectivity that we sometimes tie to the results of interpretation, and we often connect objectivity with some kind of methodology of interpretation that is supposed to help us in achieving this objectivity. From your perspective, it would seem quite problematic. So my first question would be, what do you think of this idea of objectivity? And do you think that there is any rescuing of the idea that the results of interpretation can be in certain ways called objective?
Okay. I think there is not an objective legal interpretation, obviously.
Surprise.
Surprise. No, but think just this simple point. If there were an objective legal interpretation, we would not need legal authorities. We would not need judges. I think that the idea that judges, courts exist only in order to sanction bad men is deeply flawed. It's very hard, no? Especially if we look at civil law. I have some experience as a lawyer in civil law, and in civil law trials, almost always each party, each litigant, the plaintiff, and the defendant, each party is deeply convinced that it is. And also the lawyers usually are very convinced that they are right. So that is not an objective interpretation. And so how can we evaluate an interpretation if its result is not objective? As we usually do. Precisely because there is not an objective interpretation and legal practice is conflictual, we need authorities in order to fix the solution to solve our legal problems. As far as individual cases, the final judicial decision closes the dispute. But such final decision is nothing but another step in the dance, in what, with a very nice expression, Mario Iori calls a never-ending dance between authorities, laymen, and legal experts. Surely, a judicial decision can influence other decisions, but the dance continues at least until the whole legal culture admits only one interpretative solution as correct. But in due course, such interpretative solution could be overturned by the enactment of new laws, it happens, or by the emergence of a new interpretative proposal, and then the dance will start again. I do not claim that everything goes, that all interpretations are equally correct. I think that every legal culture admits only certain interpretative criteria, which may sometimes go also beyond the very often wide limits of the literal meaning of a text. There are also shared values within each culture. However, there is often more than one admissible interpretation, and which interpretation is better depends to a large extent on the moral value, the political and legal values of interpreters. So, for example, in my studies of law and bioethics, I often discuss and criticize Italian case law decision on bioethic issues. And I criticize them not because they do not grasp the objective meaning of the law, of the text of law, but because I do not share the values that they realize, or because I share values that choose your branch. Mm-hmm. So nothing new under the sun. It's what we usually do every day.
No, absolutely. I agree with you completely. What I noticed with myself, but it might be this personal psychological problem, is that I'm still in my work, at least the last book that I wrote in Serbian, which is called The Nature and Determinants of Judicial Interpretation. I adopted quite a realist standpoint in regards of the nature of legal interpretation, and tried to kind of unpack this idea that we connect with interpretation that we often call a kind of an objectivity, even those of us who are realists, or try to answer the question of how do we reach the huge amount of convergence in interpretations. Now, one possible solution that you were mentioning is just by mentioning like legal culture values, and I was always very dissatisfied with this answer. And I wanted to elaborate on this. So I wanted to ask you too, what would be your elaboration of this, if you were forced to elaborate on this concept of legal culture and this concept of difference of values in various legal cultures? What would your further elaboration of these ideas be?
Okay, thank you. I think that there are legal culture is not the only limits, the only constraints. As I said earlier, there are also political and institutional constraints. For example, if I'm judges and I want to do career, it's better for me that I follow the president and especially the president of the High Courts. So there are a lot of limits. But when I speak of limits inside the legal culture, I mainly refer to legal concepts. Each legal culture manages different legal concepts. For example, in Italy, there is a huge construction on the concept of possession or on the concept of mens rea, which is quite different from the English one and from the UK or USA concept. And I think I discovered it's also partially different by the Polish concept of mens rea. And this sort of education is also a constraint, powerful enough So we have learned since university that we have to intend by mens rea this different kind of notions, and people are very, how do you say when people usually do what he always did? I cannot remember the English name, but
basically like
Habit,
a traditional
habit.
thing, habit,
Habitual,
inertia.
habit.
Inertia.
Habits are very strong, I think,
Yeah.
in legal culture. But for sure, it's not the only limits. As I said, I would like to study more in depth this different kind of constraints, but sometimes, not always, reduce judicial conflict.
Great, thank you for the answer. I was always, I hope that these part. Okay. Can you hear me?
Yes, but I heard a lot of rumors.
Yeah,
When I was speaking, I had a lot of noises, and I do not know if you heard them also.
Did you hear that, Jules?
I don't, but
okay.
then the thing is, let's try to mute ourselves, Bojan and I, and you can tell us whether you continue listening to the scratches or noises.
No, now they are stopped.
Yeah, now it stopped. I can't hear it anymore. But watch, the only thing that you might watch for, since you have a cable now, you might watch if you're touching the cable or moving it or something like that.
It's possible because it's not in very...
sometimes it happens, but then the noise was not reproduced in the sound of your voice.
Okay, I was fear about that.
Yeah.
No, don't you worry about that.
No, great. I hope that at one point, so my idea is very close to yours, and I thought it to be still philosophical endeavor to identify these things that we might call determinants of legal interpretation, in the sense that that we might, in a general manner, identify those influences on legal interpretation that crucially determine our ascription of the meaning. And of course, I divided them into some institutional determinants, some epistemic determinants, and some normative determinants of legal interpretation. And I don't really know if I covered everything, but it was my idea that from a realist standpoint, and of course I was obsessed with this for one single reason. Oftentimes, though this was never the realist standpoint in the American legal realism nor in the Genoese legal realism, oftentimes realism is equated with arbitrariness, which is kind of doesn't have anything to do with arbitrariness. In fact, you might still be a realist and have an insanely consistent judicial practice regarding ascriptions of meaning. But this is, by critics, oftentimes misrepresented as kind of a randomness or a lack of an explanation of the convergence of interpretation, which is quite a feature of contemporary legal systems. If you could comment a bit on this, and then we pass on to the other
basically, question. I agree with you. As I told you, my objective for the years to come is to elaborate a model that, as you told, is able to explain this different kind of influence, the different kind of interrelation among authorities, lawyers, and laymen that reduce the arbitrariness, that eliminates in a kind of arbitrariness, even if they cannot eliminate the disputes. They cannot eliminate a certain range of discretionality by judges. But this is something that I want to study in my future. But I basically agree with you, and also with this idea that there are constraints of different kind. I think, well, this is my idea, but I have to work in it. But maybe a economic analysis can provide some interesting futures, some interesting models in order to grasp or better to elaborate a model to explain this kind of influences. And interesting things is that there is much more disputes among the judges in the field which are more moral sensitive. As I told you, I work a lot in law and bioethics, and law and bioethics is a field of very strong judicial conflicts. For example, in Italy, there is a very strong conflict between high courts and common judges in the field of surrogacy. There are very, very conflicting decisions, and even if the Constitutional Court has decided, even if the Italian High Court, which is called Corte di Cassazione, had made a decision, even still the common judges are not all for following this kind of decisions. But why? Because it's an issue which is very sensitive from a moral point of view. So I think that also moral values have to enter in the picture.
Thanks, Francesca.
Yeah, I think that in this case, it is interesting because also you can analyze this from the point of view of the way in which, and going back to something that you were saying before, the way in which legal authorities talk to each other. Not talked. I'm so sorry. We said that the conversational model is not applied. I am so sorry. Interact between each other or influence each other. And then you can also think about what you are saying in the terms of that there is a threshold where we are, or the authorities, some authorities are accepting of the decisions of other authorities, and naturally this threshold maybe can be predicted or analyzed for example, in regards to which is the object of the decision, what is the culture of the values of the culture, and whether in the culture there are conflicting values, for example, in the case of surrogacy.
And also if relevant legal concepts are new or are well consolidated in the legal culture at stake. So we can expect a conflict when we have to manage some kind of new legal concepts, for example, new types of contract, respect to very consolidated contracts type. I think it's
it's very interesting also because going back to the first thing that you mentioned when you were explaining your position in legal interpretation, that you were recognizing yourself as a realist. And then within realism or legal realism, in regards to interpretation, you have different branches. And then naturally there is the Genoese one, maybe the French one as well. And the way in which you analyze, for example, the French one would be fantastic to think about these constraints. That they talk about constitutional constraints, but then also institutional constraints, normative constraints, and these explains, for example, why even if discretion is absolute in this sense, nevertheless, there is no arbitrariness in the sense of randomness, for example.
Yeah.
And then naturally the Genoese one is taking this idea of the framework and then how to construct the framework. And you were mentioning the way in which it is constructed.
Oh my God, Julieta, I have to study French.
So when the first time that I heard Michel Troper speaking, I was like, exactly.
Michel is very radical, I think, no?
He's really radical, but I think that he has some point specifically to, let's say, to rebuke some criticism against legal realism, because it is, okay, this is what happens, but at the same time, this doesn't mean that anything goes, because there are constraints, blah, blah. So I think that in that sense, he had a very descriptive
Theory.
idea, a very true descriptive idea of what is the case in our contexts. But talking about constitution, for example, and let's maybe circle back to when we were still talking about the communication theory in interpretation. You have analyzed how these the so-called communication or communicational theory for legal interpretations fares in the context of constitutionalized systems. And this is interesting because you have said in a paper, I think that it was a paper, that this theory is empirically false when you are trying to analyze the practice of legal interpretation within these specific types of systems. Can I ask you why?
Okay, my point was that a so-called communication theory, which is nothing but a conversational model of
Yes,
which
exactly.
we have already spoke, is forced in many European, Central and South American legal system, and in particular in the so-called constitutionalized legal systems, because why it is false? Because some widespread interpretative practices of this system are inconsistent with it. But by, I say again, constitutionalized legal systems, I mean legal systems that have undergone what Riccardo Bastini calls a process of constitutionalization. And one of the aspects of such process is the extensive use of an argument that we call the constitutionally oriented interpretation. According to this interpretative argument, among the various meanings expressed by a legal provision, the interpreter has to choose the one that best fits with the constitutional values. In many legal countries, like Italy, such argument is employed not only by constitutional courts, but also by common ordinary judges. In many countries, ordinary judges have not only the power, but even the obligation to resort to this interpretive argument. This is the case of my legal system. Moreover, in many legal systems, constitutionally oriented interpretation is not simply a matter of discarding those norms that are clearly in conflict with the Constitution, but rather of choosing the norms that best implement the constitutional values. It is not only a matter of consistency, but also a matter of coherence. And, well, finally, constitutionally oriented interpretation often does not select one norm among the many expressed by legal provision, but also allow judges to go beyond the textual limits. The constitutionally oriented interpretation seems to me inconsistent with any intentionalist theory, as it does not aim to grasp the intention of the legislators, even if we conceive it of as an objective intention. I think that this is particularly evident when the argument of constitutionally oriented interpretation is applied to statutes enacted before the Constitution. So, for example, in famous 1988 case, the Italian Constitutional Court ruled that all provisions of a penal code issued in 1930 during the fascist regime were to be interpreted in the light of the 1948 Constitution, and in particular in the light of the Article 27 of the Criminal Responsibility is Personal, as if they required the mens rea, and consider that no one doubted that the penal code contained strict liability offenses. But this is also evident in the cases in which courts, while recognizing that the constitutionally oriented interpretation produces a norm that does not conform to the declared purpose of a statute, the aim that the historical legislators declared to pursue, nevertheless adopt such interpretation, believing that the very manifest purpose of the statutes does not conform to constitutional values. So they put aside this purpose and then interpret the legal provision in another way. But I think that these interpretative practices are totally inconsistent with any version of a communicative theory, as well as with any theory of ordinary meaning. You know, in ordinary conversation, it would be absurd to interpret what a speaker says in the light of a context that we know the speaker cannot know. So this is the reason why I think that in some legal countries, this model, this theory is false. Again, my theory is descriptive. It's not actually, for example, a criticism to Goldworthy, because Goldworthy limits his thesis to the Anglo-American legal systems. And I'm not an expert of Anglo-American legal systems. Even if we have read a number of essays, including one by Slocum, from which it appears that the argument that Anglo-American legal culture, they call the canon of constitutional avoidance, is very similar and produces similar outcomes to constitutionally oriented interpretation. But of course, I'm not an expert of that culture. I only argue that in our cultures, such a theory is false.
And what do you think that are the consequences of this theory being false to the essential values of our democratic states, or at least these states, these European and South American states?
Well, I think the ones we see every day. I mean, I do not believe that the picture I presented leads to a collapse of democracy. Firstly, we must remember that many of our constitutions were born precisely as limits to democratic power after the tragic experiences of totalitarian regimes. So the constitutions do the work they are supposed to do since the very beginning. Secondly, it's clear that my thesis are true. Principles such as the separation of powers or the authority of Parliament weaken, but they do not disappear. The authority of Parliament and the separation of powers relate to legal text which the legal cultures usually assume as a necessary point of reference, through not an definite limit. As I said, in my view, law as a set of norms is a collective set of norms in force, is a collective enterprise. In particular, law is an intentional product in the sense that it is the product of intentional collective actions. Legislative bodies have a common intention that a given text become law. The authority of Parliament consists in this. Legislative bodies exercise the function of directing behaviors by issuing a text which they and the addressees understand as expression of legal norms. The intentionality in question, however, refers only to the enactment of legal text. Then legal text can be interpreted in different and inconsistent ways according to different interpretive arguments and the reconstruction of the relevant context. Above all, as we have seen in many legal systems, legal texts are interpreted in order to implement the values embodied in the Constitution, values which in turn are determined by the interpreters and the legal culture. But there are constraints, as we have already said. There are social, cultural, professional constraints. In general, interpreters do not work in isolation, but within institutional and professional systems. It's the same story as Hurley. They influence each other, judges, lawyers, legislators. They are in constant interaction. and they are part of common legal and social culture. Certainly, there is
constantly forgetting to unmute myself when I start speaking.
Okay.
So just for the listeners, Jules and Francesca are kind enough to make this nice gesture with their hands, indicating that I'm an absolute idiot.
Yes, a nice one.
Yeah. So my end in trying to wrap up this interesting conversation, and in the hopes that we'll have more opportunities in years and months to come to have more conversation when you are satisfied with your account of legal interpretation. I wanted to ask you about a recent paper that you wrote with Francesco Ferraro, and you advanced this idea that the dogma of the ideal legislator based on instrumental rationality has persisted in something that we call the competent speaker model based on linguistic rationality. Could you please tell us more about this?
Yes, thank you. Well, thank you. Actually, it is always the same stuff. I realize now that I'm always writing on the same topics. But, once Mario Iori tells me that we only write a book in our academic life, it's in the sense that it is always the same book. But
true story.
Yeah. But yes, in fact, he said with Francesco, we developed an idea that I had sketched in an earlier essay published on Revus. Briefly, the idea is that the theories of a conversational model which appeal to an objective intention, for example, Goldworthy's thesis, that is to the intention which a competent speaker will have expressed through that legal provision in that context, are nothing but recent modern versions of the ancient dogma of the ideal legislator. So, in a sense, they are zombies. According to the dogma of the ideal legislator, legal materials were to be interpreted assuming that they had been produced by an honest and consistent, coherent legislator who was careful to avoid all gaps in the law. That is an abstract model of a fictional superhuman legislator, very different from the actual flesh and blood lawmakers. This dogma provided a way to bypass the problems involved in identifying the legislator's collective intention. Moreover, it promised to be neutral, to construct the meaning of a legal provision as the meaning that a superhuman legislator would have communicated without appealing to evaluative considerations. But it failed. As Francesco argues in his part of the essay, this dogma can take the shape of either a descriptive account or a prescriptive fiction. As a descriptive account, it is clearly false, but it provides legal interpreters with an ideological disguise under which to actually make new law. As a prescriptive fiction, it is meant to guide interpreters in finding the legally correct answer, but so understood, it cannot avoid substantive moral evaluations and assumptions. Indeed, even if minimally constructed, the ideal legislator dogma does not just involve mere instrumental rationality, but also requires what we call reasonableness. That is a form of substantive rationality, also based on moral assumption. As I hope is clear, there is more than a vague resemblance with a conversational model, with a competent speaker model. According to the competent speaker model, legal materials are to be interpreted as if they were produced by a competent speaker, a speaker who follows all the relevant semantic and above all pragmatic rules. And also this model promises to be neutral, even if it fails for the very reason we have already discussed. For example, the competent speaker model relies on pragmatic rules, but pragmatic rules are context sensitive. And as I said, in a legal domain, relevant context can always be reconstructed in a different way. So we conclude, Francesca and I, that ascribing the rationality to legislators always implies making choices, and hence value judgments. But these choices should be public and publicly justified, and not disguised under a neutrality that does not really exist. This is, in a nutshell, our argument.
And do you think that this insistence that we identified of trying to use the conversational model to understand law has anything to do with this at some point?
Well, the competent speaker model is more or less a conversational model. According to the competent speaker model, we have to interpret the legal disposition if they were produced by a competent speaker. A competent speaker is a speaker who follows the semantic and pragmatic rules, but we follow in ordinary conversation. That's the point. Not all authors identify the competent speaker model with the conversation model, in a sense that, according to some authors, the relevant rules in legal interpretation are a little bit different, but very, very similar to the rules we follow in the conversational, but more or less is the same stuff.
Okay, well, thank you very much. I think that this is a wrap in the sense of there are a lot of things to maybe keep asking, keep thinking about, but maybe we can reserve this for a second episode also with Francesca, if she's willing.
Okay. Thank you.
Yeah, for me, I love making this recording, and I'm very especially fond of this one because it gives me nice philosophy of law breaks in between protesting against the Serbian government, which is going fine. So I very much enjoyed both this conversation and the previous conversation that we had. You were mentioning economic analysis of law and economic tools in law. The last two conversations or so that we recorded mentioned economic analysis of law and some economic tools and their usage within law and within legal interpretation. So we'll send you the links as soon as I get to editing those links. As
Thank
usual,
you very much,
Francesca. It was a huge pleasure having you as a guest, seeing
Absolutely.
you even if not in person, and listening to you talk about your work. I enjoyed as always, and love you both as a professor, as a person, and as a legal author.
Thank you very much. I love you too, and goodbye.
Bye, Francesca.